Hong Kong, the early 2000s. Picture this. A dramatic surge in a company's stock price, a sudden halt in trading, and then the bombshell announcement of a major acquisition.
Yeah, and what happens next isn't just, market excitement.
Not at all. It actually ignites this legal battle that goes on for years, and it forces a really fundamental question, doesn't it?
It does. When regulators investigate potential insider trading, are they basically pursuing a criminal matter, even if it's got a different label?
And what does that actually mean for your fundamental rights as an individual?
Exactly. So today we're diving into let's say, the real details of FACV 300-2007 and FACV 20-2007. These were two linked cases centered on alleged insider trading.
Okay.
And our goal here is to really dissect this pivotal legal fight. We want to pull out what's crucial for you, the listener, to understand about these legal processes and, importantly, the protections you have when facing potentially serious penalties.
Right. So let's set the scene. It all kicked off back in January 2000. The stock of a company, let's call them Ever-Rich Construction, just went through the roof.
Yeah. Trading gets suspended. Then comes the news. Pollon Group is acquiring a 75% stake.
A huge chunk.
Massive.
Yeah.
And when trading started again, the price was, well, like all over the place. Volatile.
And interestingly, another company, Forever International, which used to own that big 75% slice of Ever-Rich,
Yeah.
their stock jumped too.
Okay, so you can see why that would raise some red flags, right?
Absolutely.
Yeah.
And sure enough, the Securities and Futures Commission, the SFC, they launched an investigation into possible insider trading, not just in Ever-Rich, but in Forever International shares as well.
And who was caught up in this?
Well, at the heart of it were two main individuals. There was Mr. Zhang, we'll call him Officer Zhang. He was actually the chairman of both companies, Ever-Rich and Forever International.
Yeah, interesting. Good.
And the other was Mr. Chen, who was described as a business acquaintance of Officer Zhang.
Got it. So the SFC starts asking questions in 2001. Officer Zhang, Mr. Chen, they're required to answer. But this is where it gets tricky, legally speaking. Right. Because they basically said, hold on, some of these answers might incriminate us.
But they still had to answer.
They did. Under specific bits of the law back then, the Securities and Futures Commission ordinance, they were legally obligated to cooperate.
Which sections were those?
It was sections 33(4)(c) and 33(6). They essentially compelled the testimony.
Okay, but wasn't there some kind of protection built in?
There was, or, well, it seemed like it. The rule was their answers couldn't be used against them in a criminal prosecution. Big emphasis on criminal.
Except for perjury, I assume, if they lied under oath.
Exactly. Perjury was the exception. But, and this is the absolute key point, those very same answers could be used against them in insider trading proceedings.
Ah, so it's like a specific carve-out just for insider trading cases.
Precisely. It wasn't considered criminal in the same way under that specific rule.
Okay, so that sets up the next stage. Fast forward to 2003. The financial secretary steps in and asks the insider dealing tribunal, let's just call it the tribunal, to investigate.
Yep. Their job was to look into potential insider dealing linked to specific transactions on January 31st, 2000.
And identify who might have been involved.
Right. Identify any insider traders and figure out the profits they made or maybe losses they avoided because of that inside information.
And this tribunal, they had powers too.
Oh, yes. Under the Securities Ordinance, Section 17, they could compel people to show up and testify, demand attendance, demand testimony.
And Officer Zhang and Mr. Chen, they were definitely involved at this stage.
They were. They received what are known as salmon letters.
Salmon letters? What are those?
It's basically official notice telling you that you might be implicated in the tribunal's investigation. It puts you on alert that you're potentially involved.
Okay. Now, this is where the compelled testimony comes back into play, isn't it?
It really does. Because the tribunal admitted that evidence the answers Officer Zhang and Mr. Chen were forced to give the SFC back in 2001.
Including stuff that might have incriminated them.
Yes, including potentially self-incriminating statements. And the tribunal relied on a previous case, Li Guokeng.
What did that case establish?
Well, Li Guokeng had determined that these kinds of insider dealing proceedings were non-criminal. They operated under a civil standard of proof.
Which is different from criminal cases.
Very different. It wasn't beyond reasonable doubt. It was a standard of high probability that insider dealing occurred. A lower bar, essentially.
Okay, so the tribunal is using compelled evidence and a lower standard of proof. What kind of penalties could they actually impose if they found someone did commit insider trading?
They had quite a range of powers. They could disqualify someone from being a company director for up to 5 years.
That's significant.
Very. They could also order the person to pay the government an amount equal to the profit they gained or the loss they avoided.
Right, clawing back the illicit gains.
Exactly. And on top of that, they could impose fines, potentially up to 3 times the profit gained or loss avoided.
Wow, okay, so that could be a huge amount of money.
Absolutely. And they could also make the individuals pay for the costs of the tribunal's inquiry itself. So you can see, even though it was labeled civil, the consequences were pretty severe.
Definitely not trivial. So what did the tribunal decide initially?
In its interim report, the tribunal concluded that Officer Zhang was an insider trader regarding Mr. Chen's purchase of Everrich shares.
Okay.
And they also found he'd induced someone else to buy shares. Plus, they found Mr. Chen himself was an insider trader in both Everrich and Forever International shares.
And this was all based on that high probability standard.
Correct. That civil standard of proof.
So naturally, Officer Zhang and Mr. Chen weren't happy with this.
Not at all. This is where the legal fight really kicked into high gear. They appealed to the Court of Appeal.
And what was their argument?
Their core argument was that their fundamental human rights, protected under the Hong Kong Bill of Rights, had been violated during the whole process.
Which rights specifically?
They focused on Articles 10 and 11 rights related to fair hearings and the presumption of innocence, including the right against self-incrimination.
And did the Court of Appeal buy that argument?
They did. It was a major decision. The Court of Appeal agreed with them.
Really? So what did they rule?
They ruled that Articles 10 and 11 did apply here. They said that the compelled evidence from the SFC shouldn't have been allowed in the tribunal hearing.
Okay, so that evidence was out.
Right. And they also said Officer Zhang and Mr. Chen shouldn't have been forced to testify before the tribunal either, given the potential penalties.
And the standard of proof issue.
Crucially, the Court of Appeal said the standard should have been beyond reasonable doubt, the criminal standard, not just high probability.
Wow. So that completely changed the game.
It did. The Court of Appeal overturned the tribunal's findings entirely based on these points.
But knowing these things, I suspect the story doesn't end there.
You suspect correctly. The financial secretary wasn't willing to let it rest. They appealed again, this time taking the case all the way up to the Court of Final Appeal, Hong Kong's highest court.
And this must have raised some huge constitutional questions.
Absolute massive ones. The core questions were, should these insider trading proceedings, with these potentially large fines and disqualifications, actually be considered a criminal charge under the Bill of Rights, regardless of what local law calls them?
Right, substance over form.
Precisely. And what does that then mean for the right against self-incrimination and the right to remain silent? And flowing from that, what is the correct standard of proof? Should it be civil or criminal?
So that's the battleground for the final appeal, and that's really what we want to unpack in this deep dive, isn't it?
Exactly. We're zeroing in on that central conflict. Are these proceedings criminal in nature for human rights purposes? And what are the consequences of that decision for individual rights and the whole legal system?
Okay, let's get into the Court of Final Appeal's decision then. As we wrap up this part of our deep dive, that central issue, as you said, was all about classifying these proceedings criminal or civil.
Yeah, and it's such a critical distinction because it massively impacts the rights of the people involved, especially when they're facing these kinds of penalties.
So how did the Court of Final Appeal see this criminal charge issue? Did they agree with the Court of Appeal?
They did, largely. They agreed that the tribunal's power to hit people with those big financial penalties, the fines, was key. Because of those fines, they said, yes, these proceedings do count as a criminal charge for the purposes of the Bill of Rights.
Even though Hong Kong law specifically labeled them as civil proceedings.
Exactly. That label didn't matter as much as the reality of the potential punishment.
So what was the deciding factor there? Why were the fines so important?
It really came down to the severity and the punitive nature of those fines. They weren't just seen as making someone pay back profits, they were seen as punishment.
More than just regulatory compensation.
Right. The court felt these fines had a punitive, a criminal character, and that outweighed the label the local law gave the proceedings. Interestingly, they viewed the disqualification power banning someone from being a director as more regulatory, not inherently criminal on its own.
But the fines tipped the balance.
The fines tipped it. So the big takeaway here for you is that it's the substance and impact of a penalty, not just what it's called, that determines if these fundamental human rights protections apply.
Makes sense. Now, what about the right against self-incrimination? How did the highest court view the use of that compelled testimony?
They were very clear on this. using the answers that Officer Zhang and Mr. Chen were forced to give the SFC,
Yeah.
and then also requiring them to testify again before the tribunal. The Court of Final Appeal said that combination violated their right against self-incrimination, which is protected under Article 10 of the Bill of Rights.
So that protection against being forced to condemn yourself holds strong.
It does. Now, the court acknowledged this right isn't absolute, there can be limits, but completely removing the right to silence by forcing testimony in this context, they found that was a disproportionate response. It went too far.
And that earlier protection, the one saying the answers couldn't be used in criminal cases, that wasn't enough?
No, because the answers were being used in the tribunal proceedings, which the court had just determined should be treated as criminal for rights purposes because of the fines. So that statutory protection was insufficient. It didn't cover this situation adequately.
Right. It highlights a potential gap. Legal safeguards need to work across the board when fundamental rights are engaged.
Exactly. Not just in proceedings formally labeled criminal.
Okay, and the final piece, the standard of proof. What did the Court of Final Appeal say about whether it should be high probability or beyond reasonable doubt?
They basically endorsed the Court of Appeal's view. If proceedings amount to a criminal charge, then the standard of proof has to be beyond reasonable doubt.
Aligning with the presumption of innocence.
Precisely. That's a core principle under Article 11 of the Bill of Rights. If the state is effectively bringing a criminal charge, even if it's called something else, it has to meet that high standard of proof.
Did they comment on that high probability standard itself?
They acknowledged it's used in serious civil cases. It's sort of a nuanced standard, but they definitely didn't say it was the same as beyond reasonable doubt. The clear implication was, for proceedings like these with those fines, only the criminal standard would do.
Okay, so summing up the court's findings. The fines made it criminal for rights purposes, the compelled testimony violated self-incrimination rights, and the standard of proof should have been beyond reasonable doubt. What was the final remedy then? What actually happened as a result of this ruling?
This is where it gets really interesting. The Court of Final Appeal declared that the tribunal's power to impose those fines under Section 23(1)(c) of the Securities Ordinance was invalid.
Invalid. So they struck down that part of the law.
Yes, because it was incompatible with the Bill of Rights. However, and this is the twist, they upheld the tribunal's original findings that Officer Zhang and Mr. Chen had engaged in insider dealing.
Wait, how could they do that if the process was flawed?
And they also upheld the disqualification orders.
Right, banning them from being directors. Why? That seems contradictory.
The court's reasoning was this. Once you remove the power to impose the criminal penalty, the fines, the proceedings themselves could then be properly viewed as civil or regulatory in nature.
Ah, so take away the fines and the criminal charge aspect disappears.
Essentially, yes. The disqualification orders were seen as regulatory measures designed to protect the market's integrity, not as criminal punishment in themselves. So with the fines off the table, the rest of the tribunal's actions, including the findings based on the evidence they had, even if some was compelled, and the disqualifications, could stand as part of the civil regulatory process.
Wow. That is a delicate balancing act.
It really is. It shows the court trying to protect those fundamental individual rights connected to criminal charges, but also trying to uphold the public interest in regulating financial markets and dealing with insider trading through other means, like disqualification. They struck down the incompatible part, the fines, but salvaged the regulatory aspects.
Okay, that's a fascinating outcome. So it leaves us with a final thought, doesn't it? Something for you, the listener, to chew on.
Definitely. How should society strike that balance? You've got the critical need to regulate complex financial markets, things like insider trading, that can really damage public confidence.
But on the other hand, you have the fundamental rights of individuals who get caught up in these investigations and face potentially life-altering penalties.
Does this case maybe suggest we need much clearer lines, legally speaking, between what we consider a civil regulatory matter and what crosses the line into being essentially criminal, especially when it comes to financial regulation?
It's a tough question. And it makes you think about the broader implications, right?
Yeah.
Beyond just finance. How do we handle enforcement and individual liberties across all sorts of regulated areas?
That's the lingering question.